Jordan Caldwell. Ms. Caldwell, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer is dispatched to a residence in Harris County, Texas, in response to a family disturbance. The complainant stated that she got into a verbal argument with the defendant, her daughter, because the complainant believed the defendant was not taking care of her children. At that point, the defendant picked up a baby bottle and threw it at the complainant, hitting her in the cheek, causing pain. The defendant admitted to having thrown the baby bottle.
Ma'am, I'm going to find that there's probable cause to go forward with your case. I don't show a protective order as an issue. Do you show one? No? Okay. Ms. Caldwell, I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Candy Lachey as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? Is not an answer, ma'am.
Yes.
How old are you, ma'am? Are you here with anyone today? Who are you here with today?
My boyfriend.
I'm sending you now for a drug test. I want to know what, if anything, is in your system, ma'am. You're to come right back. If you fail to take the test, if you fail to come back, I will issue a warrant for your arrest. You will not get any more PR bonds. Do you understand? Okay, can you have her sign the note before she leaves, and then we'll send her for a test, please?
You're done with it, Your Honor?
For now. So just normal reset. Everything is normal.
Okay.
Nothing special. Just stay out of trouble.
I believe her bond conditions require her to not go to the residence at issue. Her two children, right, are still there, and I'm not clear who
is the complaining witness again?
her mother.
Do we know if mom wants her back?
Let me see if it's been. It has. Let me read this.
The only time I say no is when the complaining witness says no, because I want to honor their wishes. If the complaining witness is okay with it, then I am too.
Your Honor, the complainant is fine with contact. She just wants no threatening, harassing contact.
Okay, that's it. We'll let you go back to the home, but you have to understand what is threatening or harassing. Doesn't matter what you think. I'm trying to.
Understand?
Okay, I'm listening.
It's how she perceives. So when you start going like this, is that threatening or harassing? It is. So be careful how you act, because if we find that you're threatening or harassing the complaining witness, I will revoke the bond and put you in custody. All I'm asking you to do is be nice. That's it. If you constantly bang heads with your mom, be careful, you know?
Not only that, you could also get charged with violating bond conditions. All right.
Protective order. And then,
Protective order.
yeah.
Can we make sure the protective order mirrors the bond conditions?
Sure.
Okay.
Caldwell. Do you mind printing out? Okay, ma'am. We've given you a lawyer. It's your responsibility to stay in touch with Corey. He'll tell you when you have to come back to court. I'm going to waive your appearance so you don't have to waste your time coming here, but just stay in contact with him and he'll tell you when you have to come back, and just be nice. If mom kicks you out, where are you going to go? You got two kids too, right? That's what you got to think about when you're out there. You just get in a fight with mom, they kick you out. Where are you going to go? And you got two kids. You can stay here with us. I don't think you're going to like that though. It's not, you know, it's not fun. Okay, so I'm going to amend the conditions and then you guys are good to go.
Okay, thank you, Judge.
For sure. Thanks, Corey. Come on.
So go to the middle.
I have a Norma Solano on today's docket. It looks like she had missed a drug test for bond, we're here for
Is she
bond
here
violation.
now?
Oh, yes, Judge, she's here.
Okay.
And she said she was not aware that she had the drug test. I don't know if the manner in which they contact them, I thought they maybe call them for that. But she was originally going to do DWI PTI. She now says she would like to take a time served offer. Would you allow her to do that today?
Why? Why she doesn't want to do the,
Judge, she just said she
she know
doesn't.
what's he going to test positive for? Is that what it is?
No, Judge, but she just said that the expenses of the program and she's working right now and she doesn't have time for the program.
Come up, Miss Solano.
But we had already gotten her approved and we're kind of on our way to, I think we might even have the contract already even for DWI PTI.
How old are you, ma'am?
25.
Okay. You know, being in court, it's not like being in Target, Costco, HEB, where if you don't like something, you can return it or you get buyer's remorse. When you make decisions in here, they're lifetime decisions that you have to live with forever. And, you know, there are collateral consequences that may arise, meaning consequences that you may never see pop up as a result of decisions that you make in here. When you plead guilty to an offense, that offense goes on your record and it's there for the rest of your life. And when you plead guilty, you can't take it off. You cannot say, you know what, I have a change of heart. I can't get an apartment. You know what, let me go and try to do something else. Once you plead, you're stuck like Chuck for the rest of your life. I tell you now, I have, you know, every month, people that call me, they go, you know, this lawyer pled me to this case and I can't get an apartment. Can you take it off? I have, like, they pled 10 plus years ago. You know, truck drivers that want to better their life, but they pled guilty to a, you know, a less than a gram case and can never take it off. When you plead to a DWI, not only is it very possible that you lose jobs with regard to, you know, making a living with a car, your insurance is going to go up. Your insurance is going to skyrocket. Insurance is expensive as it is now. You pick up a DWI, it's going to be about 4 times what it is now. Not to mention any other consequence that can arise from a DWI conviction. You have the opportunity now where if you are granted entry into this program, if you complete it successfully, they dismiss the case. It looks like you've already have been granted entry into it. The only problem I see now is that you were called upon to take a drug test and you failed to go. I'm going to go send you for a drug test regardless, right?
Yes, sir, that's fine.
Right? But when you take a half-ass approach to something, you get a half-ass result. And it's usually not a good idea to do that with a criminal case. You know, when you try hard, you get a good result. You know, James worked hard to try to get you into this program. Has she been already admitted into it? Do you know?
She's not in PTI, Judge, but she's been.
Right. But right. I mean,
Yes, Your Honor, the last update was that the contract was signed, the NDA was in.
all you
and-
literally need to do are 2 things. You pay the DA fee and you get an interlock. The DA fee, if you fill out a waiver, they may be able to waive that $300 fee. As far as the interlock, I can't pay for that. I can only pay for it while you're on bond. That's something that you'll be required to pay for. But I tell you now, the $50 to $75 cost you per month now is nothing compared to what you will end up paying with the DPI conviction. So you make the decision on what you want to do. I am going to send you for a drug test right now, regardless,
Yes, that's fine.
and alcohol test.
Yes,
But think long and hard before you make this decision because there's no turning back from it. Okay? Okay, man. Just hang tight for me.
You want to approach?
Sure.
Judge, we got Norma Solano's test results and she came back negative. What I was gonna,
Hold on. Hold on.
sure, Judge.
Who is it?
Norma Solano, you sent her to go get tested?
Is that Miss Solano?
Yes, Judge. She's right over there.
Come up, Miss Solano.
That's kind of a alternative as opposed to having her plead today. Maybe we can get.
No, I don't want her to.
No, I know you
She
don't.
doesn't want to.
She wanted to do time served today, but I was thinking just instead of that, because she's already has the contract, maybe we can give her a couple weeks to talk to some friends and family and see if she would rather
What
go.
do you want to do?
You said you want to do the time served, or you think you want to do the 1-year program?
Well, I was iffy
In the beginning, I just wanted to do the time served, and then I talked to my friends and my family, and they suggested to do the program. But since I got,
Anytime you can get something dismissed, no matter how, that's always the best result, really, because like I told you, the consequences of a DWI conviction, they're staggering. You never know how it's going to affect you. It will. It's going to affect you. It's just, you never know how and by how much. And with the DWI is big business. You plead guilty, from now on, you're looking at a minimum of 30 days in jail. You're also looking at a mandatory about $6,000 to $7,000 in fines and fees just here from court. Not to mention insurance going up, not to mention all the other stuff in your life, how it's going to affect you. Whereas if you do this program, you do well, maybe they'll even boot you out early. If you do everything speedy, you do it quick, maybe they'll take you out early too. Just depends on how well you do. But you have to put effort into it.
yes,
All you do is, there's 2 classes, right?
There's a couple classes and then it's the alcohol monitoring device.
And there's 2 classes, a little community service, and just stay clean. That's all you have to do.
I have clients regularly do everything in 6 months.
Take your time. I don't want you to rush into something now. So we'll set you off a couple weeks. In the interim, do we have the financial affidavit so we can have her doing that as well?
I can send you a copy of the financial affidavit to waive the $300 fee if you qualify, but you need bills and pay stubs and all that to be attached. I can send that to her, Judge.
Please. And I think we may even have a copy here actually for you. So, try to get that $300 fee waived, and then all you have to do is pay for the interlock and just stay clean. What do you think? We'll give you time. I'll give you a couple weeks. If you still want to do the time serve, that's on you. If you want to do the program, great. It's up to you. Take your time.
I think,
Yeah, just
Okay.
talk about it.
yes,
Take your
sir.
time.
Thank you, Judge.
I'm glad that you're clean and don't miss again. Okay? All right. Good luck, Ms. Lano.
Thank you, Judge.
For sure.
Hey, quick question.
Ricardo? Antonio, what's his name?
His name is Cesar Alvaro.
Good morning.
Yes.
Your lawyer has tried to work out an agreement with you. The problem is that it's going to take a while. And sometimes for a good result, it may take a while for that to happen. Here, his advice was for you to set it for trial. But unfortunately, because of the holidays coming up, normally we do a 30-day trial setting. But 30 days from today runs into the Christmas time, and we don't have any juries here. So the first jury trial setting that we have is for January 7th, and he wanted to set your case for jury trial on that day to see whether they can make the case or not. I know that you're itching to get out, but you got to understand that if you plead today, there are very serious consequences. You're charged with assault of a family member. This carries an affirmative finding of family violence. What that means is that if you ever pick up another one of these cases again, you will be charged with a 3rd-degree felony, and you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. And when I mean an assault, it doesn't have to be a beat down with blood everywhere. Simple fact is you grab someone's arm and squeeze it to where it hurts. That's enough for them to charge you with a serious felony where you're looking at 10 years in prison. If you do this, you can never own a gun or ammunition as well. So the advice by your lawyer is for you to wait a bit and set up a trial January 7th. What would you like to do?
Mejor si lo espero el 7 de enero.
I'd rather wait for the January 7th.
Okay. Antonio?
Yes, sir.
There you go.
Yes, sir.
Yeah, and we'll set up a trial for January 7th, and we'll see what happens. You know, that's the advice of your lawyer. I would, you know,
Okay.
yeah, okay, here you go.
Yes, Judge. All right. Thank you, Your Honor.
All right, absolutely.
Okay. Okay. Yeah, this was the last one.
Okay.
Good morning. So, Mr. Hercules, you were charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. You guys have worked out an agreement where they're offering you 3 days in jail, credit for the 18 days that you've done. You sure?
Yeah.
3 days in jail, credit for the 18. You know, the way that you were driving in that parking lot, God forbid that you hit someone, kill them, run someone else over, driving out like that and then bolting out at 90 miles an hour in a parking lot. You're begging for trouble, man. Can you imagine if you hit and kill someone? Who gets charged with murder? Mr. Hercules.
You're right.
So, you know, in a parking lot, that's not the right place to do it. If you want to do it, there are places in Houston, but not in a parking lot, man. How many racing facilities are there in this town? I mean, a lot. Don't do it again. I'm going to tell you one more thing, that the legislature has made it really easy for DAs across Texas to seize and take cars away from individuals who do this. You are now going to end up with a conviction for this on your record. You pick up another one of these cases, it's very possible that they seize and take that car forever and you don't get it back. Do you understand?
Sure.
The right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never change this. Is this what you want to do? How do you plead to the offense? Guilty or not guilty?
They give me the time served.
Yes, you get the time
Yes.
served.
Are you guilty of this offense?
Yes, sir.
Okay, all right. I'll find you guilty. I'll send you the agreement. Now, we're not going to release you today because Louisiana wants you. So you'll probably Monday or Tuesday be out of here and then on your way to Louisiana. Okay. Good luck over there.
Thank you, sir.
All right. Take care.
Yeah, I like
Mr.
your sports jacket. It looks nice.
Thank you, sir. Take care.
All right, Mr. Hernandez, have a good one. Your Honor, may I be excused? Thank you, sir.
And with that, that's it. You done?
Well, you're good.
Oh, okay.
In your honor, briefly on Williams, were those state's conditions or pretrial for the marijuana? Is that a state's condition for bond or pretrial?
Good job.
Okay.
Did you want random testing or?
Do you know why you're here?
Yes, sir.
Why are you here?
Because I didn't finish my community service. And my class, I did finish, Your Honor, but I got into a tight budget. Very, very bad.
One of the only other things we asked you to do, don't use drugs or alcohol.
Yes, sir.
And now you're testing positive for cocaine. You tested positive for cocaine in February, and you've just now tested positive for cocaine again. Take a seat for me in the jury box, sir.
Good morning, Your Honor. Good afternoon, Your Honor.
Yeah.
Judge, I am here on Mr. Alejandro Guardado. Looks like it's an MRP judge. I've been informed that
Come up, Mr. Guardado.
my client had tested positive for cocaine, I believe. I think this is his second or third time testing positive. We want to know what direction you.
Hey, this isn't the club, man. You. Saw you trying to talk to her. This isn't the club, man.
Sir, no, sir.
Yes, yes, sir. Yes, sir.
Get your brother. Mr. Guardado, you were placed on probation for a very serious case and you've had issue after issue. The reason I brought you here was try to ensure that we could get you on the right path, but you're continuing to use, and you just today tested positive for cocaine again. And I'm at a remiss that they didn't even inform us in February when the first time you tested positive for cocaine. So now I'm issuing a motion to revoke your probation and I'm issuing a warrant for your arrest. I've appointed you a lawyer so we can figure something out, but you can't continue to use cocaine while you're on probation and expect good things. Do you understand?
Yes, sir.
Okay. So what I would suggest at this time is we probably get a TRAS to see how we go forward, because I just don't know.
Yes,
You're
sir.
using, and that's not something you're supposed to be using, you know? It goes with you.
Yes.
Thank you.
All right.
How much you said in the bond, Judge?
What's it at now? 5,001.
Judge, I have Evan Nelson, and we're approaching because of the age of the case. Wanted to also just update you as to what's going on with it.
Okay.
We have talked, my client and we have asked the state to evaluate this one for trial. They did make a 3-day time served offer, which I presented to my client. And he is not amenable to accepting that, just based on the elements of the offense. So we talked through those.
You know, Mr. Nelson, the only problem I have is that you don't show up. We've already had, you've been given one GOB, you've been given one PR bond, and now you've made a surety bond. You miss again, I'm gonna make your bond so high, your hair's gonna look like mine. You know what I mean? You're gonna be losing it because you're gonna be so upset. So don't miss again, really. Giving you a great lawyer, all you gotta do is stay in contact. What offer have you made on Mr. Nelson's case?
It looks like Pavel had put in a time served offer when he was still on.
Is that it?
I'm welcome. I mean, I'm happy to talk to counsel, about another
Okay,
offer. This is just an old offer put in by Pavel.
okay. Oh, yeah, it's a prior assault dismissed. Okay. We'll give you guys some time. It's not gonna be too much time because your case is already 190 days old. So it's time to figure out what we're gonna do. We'll give you, 3 weeks. But at that time, you gotta come back and we gotta figure out what we're gonna do. At that time, in 3 weeks, if you don't accept anything, I'm gonna set your case for trial. Okay? All right, guys.
Thank you,
Okay.
Judge.
Good luck. See you in
Thank you,
3 weeks.
State. Have a good weekend.
Sure, is there gonna be any bond conditions? Because we just put them in the box straight away.
Just no weapons, I guess. That's it. He's a prior AFM, so yeah.
All right,
Okay.
so state
So
bond.
Morgan, do you mind following? Just no weapons.
Yes, Judge.
If it's not already there, I don't know.